On behalf of our thousands of members and supporters across the state, we are here respectfully to testify against SB 892. At the ACLU of Texas for 75 years, we've shared the belief that government should make reasonable accommodations so that Texans can practice their faith freely. In fact, it's a critical part of our mission. That is because religious liberty is, after all, a defining value of American democracy. However, in our view, SB 892 goes far beyond religious accommodation, reasonable accommodation, and actually puts the thumb on the scale in a way that overrides other important and compelling interests. I was surprised to hear testimony earlier today to suggest that this bill is somehow necessary in a state like ours where we have done so much to protect religious liberty. People of faith already enjoy extensive constitutional and statutory protections, including, for example, our Texas Religious Freedom Restoration Act, which is an example of a religious accommodation bill. It puts a particularly heavy burden on government to avoid burdening faith beliefs. There's no evidence that these existing laws are insufficient to protect the faith beliefs of providers who are called to, as we've heard today, serve the orphan. We also are concerned because SB 892 attempts to redefine the traditional conception of free exercise under the First Amendment, literally the first liberty protected by our U.S. Constitution's Bill of Rights. Free exercise does not confer a right to act in a way that harms or discriminates against others, and it doesn't include the right to demand that taxpayers subsidize personal religious expression that is contrary to good public policy. Under our system, everyone, regardless of faith, must play by the same rules. Moreover, SB 892 violates the Establishment Clause, another very important limitation on government's ability to interfere in people's religious liberty. It does that because it gives certain faith beliefs a privileged position in our child welfare system. It allows the adherents of those favored faith beliefs to enjoy special privileges under the law, and for those who don't adhere to those faith beliefs, who share different faith beliefs, they get no such protection. That kind of a two-tiered system can't be reconciled with the Free Establishment Clause. As a result of these constitutional infirmities, SB 892 exposes the state to liability to families and children who face discrimination by the state's contractors. We urge you to make corrections to the bill so that you can ensure that the conditions of religious liberty are protected, not only free exercise, but also the Establishment Clause. Thank you.